And I wanted to welcome back my vice chair. I know that I asked you. His little ears were clogged, so guys, just be gentle. We can't yell today. We gotta let him suffer through this, but he went through something that you feel better now, right, Brian?
I'm good.
There you go. So guys, just be gentle today, all right? He went through a lot. We have our first bill with Chairwoman Peña-Melnick. Right before, and please come up. But before you speak, I'd like Delegate Adams has something.
Thank you, Mr. Chairman. Let me just say, you may ask, I'm a private business owner, how does my business run when I'm not here for 90 days? It's because I've got family in the business. My youngest son's here today. Mitchell Adams is in the back. So he's here on leadership training with Associated Builders and Contractors. So at some point he's going to take the business over if I'm fortunate. So thanks. Yeah.
Well, you're very welcome. You get to see your dad be a menace today because that's what he gets paid to do. So he does it in a good way, though. So congratulations. He's a wonderful guy. Great add to the committee. Madam Chair, if you would.
Yes. Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the committee. It is an honor to be in front of you. Thank you for making accommodations so that I can go first and I can then head out to my committee. Today, I am not going to be providing the testimony on House Bill 825, but my amazing intern is going to provide the testimony, and I know she's ready. So go ahead, Riley.
Chair Wilson, Vice Chair Crosby, and members of the Economic Matters Committee, thank you for the opportunity to present House Bill 825. My name is Riley Dove. I am a Maryland Corp Service Share Option member. I am currently placed in the Department of Legislative Services as a host site, and I have the blessing to be in Delegate Peña-Melnick's office for the session. Currently, the board has 11 members, 3 appointed by the governor, 3 appointed by the Senate President, and 3 appointed by the Speaker of the House. 2 serve ex officio. House Bill 825 adds the comptroller or the comptroller's designee as a member of the Maryland Small Business Retirement Savings Board, which oversees the Maryland Small Business Retirement Savings Program and Trust. The program provides an essential service by requiring certain private sector employers to offer their employees a retirement savings option. Employers who participate in the program not only help their employees build financial security, but are also exempt from state's annual filing business fee. A win-win for businesses and workers alike. By adding the comptroller or their designee, Maryland would be following the lead of states like California, Illinois, New Jersey, and Connecticut, all of which have included their state comptroller in similar boards. The comptroller's expertise in financial oversight, tax administration would enhance the board's ability to ensure effective management and implementation of the program. The comptroller has already been working closely with the board to help with topics like the sharing of data, resource management. This bill is just making it official. I want to emphasize that House Bill 825 has already passed the Senate, and this bill has no fiscal impact on the state. This is a simple but meaningful change that will strengthen Maryland's retirement savings program and help small businesses and their employees secure a more stable financial future. For these reasons, I respectfully urge a favorable report on HB 825. Thank you for the opportunity.
Good job. You go ahead.
Oh, hi. My name is Glenn Simmons. I'm the Executive Director of Maryland Saves. Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the committee. Thank you for the opportunity to be here today to present my support for adding the comptroller to our board. Comptroller Learman has been a strong and visible supporter of Maryland Saves since actually before its inception, when the originating legislation was being considered in 2015/2016. Over the past 2 years, she has continued her support for Maryland Saves in her role as comptroller by enhancing our communications and marketing efforts and working with the General Assembly to enable her office to share contact information for Maryland businesses that do not offer retirement plans. I'm convinced that adding the comptroller to our board of directors will enhance our program, improve our communications, and generate more awareness in the program. It also supports our goal of making a workplace retirement plan available to every working Marylander. For these reasons, the chair of our board and I respectfully urge a favorable report on House Bill 825. Thank you.
See one question? Delegate Weigel?
Thank you, Mr. Chairman. My only question, is this a voting or non-voting member?
It will be a voting member, ex officio.
It would be a voting member, but the fiscal note says the treasurer or their designee is, they're non-voting?
They're voting as well.
Oh, they are?
Yes, every member on the board has a vote.
Okay, it says the treasurer and secretary of labor are non-voting.
Oh, they definitely do vote.
Okay.
That should be corrected.
So the fiscal note must be wrong. Thank you.
We need to correct it. And we'll do that. We'll take care of that.
Delegate Rogers?
I was going to give the original person testifying a hard time, but I'm going to commend her for her excellent testimony, and I'll make sure her mom and dad knows as well. Good job.
Thank you.
Thank you.
Delegate Chi?
Thank you, Mr. Chair. First of all, I appreciate this bill and a very simple bill and testimony. I just want to, as a point of clarification, a couple years ago when I introduced a bill to require the comptroller's office to share some basic business contact information like address and email and all that in order for you to be able to do your job to inform businesses that this program exists. And at no cost to employers, they can sign up their people to join this retirement savings program, right? So now the comptroller's office has a stake in the game, which is another reason why that person or the office needs to be involved in the program administration. So as a point of personal privilege, I want to ask you how many businesses since 2 years ago, when the program actually started, have signed up?
We have just under 5,500 employers registered with the program. And of that 5,500, about 1,500 of them are actually actively participating. And by that, I mean submitting payroll contributions for their employees.
Great, thank you.
Yes, ma'am.
No other questions? I believe that concludes the panel. Thank you very much, Madam Chair.
Thank you.
Great job, young lady.
Thank you.
Thank you very much.
We have Tammy Bresnahan? No? Okay. Well, that concludes this bill hearing. Moving on to the next bill, House Bill 575. That's Office of the Attorney General.
Are you ready for me?
Yes, ma'am.
Okay. Mr. Chair, Vice Chair, members of the committee, Jessica Finberg on behalf of the Office of the Attorney General. The Office of the Attorney General requests a favorable report of House Bill 575, which will modify Section 2G of the Maryland Port Act to reduce the frequency of reporting required from the Attorney General to the General Assembly on the office's efforts to recover all possible economic damages arising from the closure of the port and the collapse of the Francis Scott Key Bridge. As you're aware, the Attorney General is pursuing litigation against Grace Ocean Private Limited, the owner of the MV Dolly, the ship that collided with the bridge, and Synergy Marine Point, the manager of the MV Dolly. On November 7th, the United States District Court for the District of Maryland determined that the litigation would proceed in 2 phases. The state, along with many other claimants, are currently litigating the first phase, which will determine only whether the owner and manager are entitled to a limitation of their liability. Fact discovery is still ongoing and will continue until July of this year. Expert discovery will continue until the end of February 2026, and the trial for phase 1 of the litigation is set for June 1st, 2026. After phase 1 is complete, the state will then litigate the merits of its claims. Litigation deadlines or trial dates have not been established for the second phase, but it is expected that the merits phase will have a timeline as lengthy as this limitation phase. Currently, under the Port Act, the Attorney General is required to submit monthly reports to the General Assembly describing the status of the Attorney General's efforts to pursue and recover all possible economic damages. Much information regarding the pending litigation, including communications by the office with assistant counsel and agency clients, legal analysis and litigation strategy, and conversations with witnesses, are privileged or otherwise are protected attorney work product. As such, we can only report on aspects of litigation that are known publicly, such as decisions by the court. Therefore, to date, our reports have predominantly provided short updates explaining that the Office and Assistant Counsel continue to engage in factual discovery. And I submitted one of these reports with my written testimony. So given the timeline of the ongoing litigation and the pace of events about which we can even report, is the assessment of the Attorney General that a 6-month reporting period will better serve to keep the General Assembly meaningfully and substantively informed of the office's efforts. I'd also like to note that the Senate version of this bill passed unanimously today. Thank you.
Thank you. See no questions. We'll move on to our next hearing. Thank you very much. Next bill, Delegate Vaughn Stewart, House Bill 795. Do you have a panel, sir?
I don't think so. I mean, yeah. There were hundreds of people that wanted to come testify, but I told them to just be, gracious and generous with the committee's time. And I know obviously the vice chair is still recovering, so.
I appreciate it.
Mr. Chair, Mr. Vice Chair, nice to see you, members of the Economic Matters Committee. So this bill is about a topic that will be near and dear to all of your hearts, which is the Family Medical and Leave Program that this committee passed and is still considering changes to this year, but passed and has been working on for years and years and years. And it makes a relatively simple and what I hope will be a non-controversial change to the program. Right now, to be eligible for the family program, now all workers and employers, for the most part, pay into the program. To be able to benefit from the program, you have to have worked 680 hours within the last 12 months. So you have to work a pretty substantial time within the last year. So the reason for this bill is that there are a lot of people in the state who would love to benefit from the Family Medical and Leave Program who cannot meet the 680 because, for example, either they were a student in the prior year or maybe they took time off to care for a child who was born earlier than the one that they're conceiving at the time. So the idea behind this bill is rather than go in and just expand the eligibility and tinker with the program and add a bunch of additional expense, we've come up with what the bill calls an alternatively eligible individual, such that if you've worked what the SSA, the Social Security Administration, considers 1 year in your lifetime of earnings, then you can get a minimum payment of $2,000. And maybe $2,000 is too high. Maybe the number is more like 1,000. But the idea is if you have paid into the system at all, at least a little bit, you've worked a little bit of like a year in your life, maybe not within the last year, but you've worked some, that probably means you're going to re-enter the workforce and pay into the program. So you should be able to get some minimum cash payment to help you during this leave policy. And here's the general idea behind this bill is pretty straightforward. Family and medical leave insurance, an insurance program, as this committee knows all too well, but it's unique from a lot of other insurance programs like health insurance or workers' compensation, where you've paid in for a long time with those programs usually, and then towards the middle of your career or the end of your career, you want to pay out. Family medical leave is unique. It's the only program where really you're taking this early in life, before you've had an opportunity to pay into it all. So the idea behind this bill is for people who are just at the start of their career, they've only paid in a little bit, but they have worked at least a year. Let's not let them opt completely into the family leave program because we don't want to bankrupt the program. It's already a massive program. So instead, we'll say if you've worked a little bit, as long as you've worked for about a year, you're not eligible for the full program, but we'll give you $1,000. Because we know probably since you've worked a year before, by the time your career ends, you will have more than paid that $1,000 back. Otherwise, we're going to be in a position where a lot of folks are going to be paying this on their payroll tax every month, and then they're going to be surprised to hear that because they were taking care of another kid or because they were in school the year prior, they're ineligible for the program. So that's it. Fairly simple. I urge a favorable report.
Delegate Vaughn, Stewart, apologize. I know that you, as a highfalutin attorney, things get very expensive. This one says about $60 million.
Yes, so it is brought down with I have some sponsor amendments that brings it down. There are two reasons. Well, the main reason that says that is there's an inadvertent drafting mistake, which is that the bill actually says that it includes unemployed people. And the fiscal note assumes that we're also covering unemployed people's costs too. That's struck. And then also, what I mentioned is if we take that $2,000 benefit and bring it down to $1,000, we would half that more. But remember, even let's say it's $30 million, this is a $1.6 billion program. So if you add $30 million to 1.6, you're talking about like maybe in order to cover this benefit, you're talking about maybe every worker pays like maybe an extra 3 cents in every pay period. Because it would be essentially like a 1% increase on the cost of the program.
I think, because, you know, this is one of my concern with my children is family medical leave program that I worked on. And
Right.
I felt like we had to draw a bright line somewhere. But you kind of
Right.
just want to get rid of the line altogether?
No, I don't want to get, I had that option, right? I could have actually just completely changed the eligibility.
I mean, you had the option.
To propose
put in
it,
your-
to
there you
propose
go.
it, yeah,
I wanna make
exactly.
sure, right.
I had the option to propose expanding the eligibility.
Sure.
And reconfiguring the committee's hard work on that. I did not choose that option.
Thank you.
Yes, I know, and in all my generosity. Instead, what I'm saying is, we shouldn't expand the eligibility. Let's keep the eligibility tight. Let's keep the line draw where we are. But if someone, let's say they haven't worked a ton in the last year, but they have worked a full year at some point in their life, maybe they're just 22 and they're getting out of school or whatever, let's not let them enter the program because that actually would really balloon the cost of the program.
Right.
But let's give them something. Maybe 1,000 is not the right dollar amount either. Maybe give them $500. But let's make sure we include them in the program because otherwise we're going to have hundreds of thousands of Marylanders who are paying into this early in life, not benefiting from it, and then spending decades paying more into it afterward.
Yeah, because I guess my concern, as we're talking, is the solvency of the program. It's
Of course.
It's not up and running yet. It's always weird to tinker with things that aren't even active. And we honestly don't know when that's going to take effect, right?
Right, and I mean, I thought about this too, right? Is it better to tinker with a program that hasn't launched, or is it better to tinker with someone once it's actually launched? And I
you
mean,
said
there are
that
pros and cons, but yeah.
All right, well, that's one way of looking at it. So it's an expensive program either way, but, and again, my issue is always definitely obviously with the issues with solvency because we're already kind of walking a tight line with that. They'll get cheap.
Since the chair already brought up the solvency issue, my related question is where the Maryland Department of Labor is on this. And also, I know Maryland is now one of a dozen-ish states that have some iteration of this program. I just wonder, you know, if we are an anomaly in being out there as the
Right.
first state to be more lenient on this front. Thank you.
Both are good questions. The Department of Labor did not officially weigh in as far as I know. You guys have the bill file. I don't think that they've weighed in one way or another. We did have some conversations with them. Their concerns were mostly having to do with the administrative cost of doing this, and I think that's reflected in the administrative cost of the fiscal note. To answer your question, other states do have more generous eligibility than Maryland does for the program. No other states have created essentially like a little offshoot eligibility like I have in this bill to essentially say if you don't meet the eligibility but you still worked a decent amount, we're not going to let you in the program, but we'll give you a little bit. No state has done that, but other states have been more liberal on eligibility.
Thank you, Mr. Chair. You know, usually your presentations are always like funnier, you know, you come with
Yeah,
a
I know,
story. This
I
is
know. Well, when
like-
you set such a high bar, you know, you
It's
can't
all
like clear
serious-
it every time. I know.
serious business. So you alluded to this. So in the fiscal note and then some of the testimony from the chamber, they're saying that this bill would provide benefits to people that don't work. I know you mentioned that. Can you at least address that issue?
Yeah, sorry, I mentioned that already. So that was a mistake. We have a sponsor amendment. It's not meant to help.
Alternatively qualified person is a person that doesn't work.
No. An alternatively qualified person is a person who works but didn't work much in the last 12 months.
Okay.
We did not mean to include unemployed people.
All right, and so assuming that comes out of it, then really it would just be the ask of this committee would be to amend the eligibility in the scenario of a young parent, something to that effect.
Yeah, I mean, let's
where
just
they
take.
haven't
Yeah,
paid into the system enough, but we're going to give them the benefit of the doubt up front.
You give them something. You don't give them the benefit of the doubt and let them in the program. You just give them a fraction of what they would have if they actually qualified, right? So if you take an average, like, let's say 23-year-old, she's been working at Waffle House since she was 18. She worked Waffle House when she was 18, 19, 20, 21. but then maybe she went back and tried to get an associate's degree. Or maybe she had her first child and had to take off from Waffle House so that she didn't meet that 680 hours in the last year. Well, she's still paid a fair amount into the program. She's probably going to be pretty surprised to learn that she's not going to be able to benefit for the program. But even more importantly than that, she's now got another 40, 50 working years left where she's going to be paying into a program that she never received any benefit from whatsoever. So what this bill says is, it would be too expensive given the huge cost of this program. It would be far too expensive at this point and also too late in the game to change the eligibility entirely. But for this population of folks who have worked a lot in the past, didn't work in the last 12 months, let's not let them in the program because we got to contain cost, but let's give them something. Let's give them $1,000. And that way they get a little bit back from a lifetime of paying into a program that just because of how the timing didn't work out, they weren't able to benefit.
Okay.
I'm sorry that I'm not very funny today. I'm sure I'll try to fix that in my next one.
Yeah, I mean, when you're asking for this much money, it's hard to move on.
Yeah, it's a sober time.
I want to be very clear. So we're your standard is now, because we had the 680 hours, your standard is in a lifetime, they had to earn $7,200.
Yeah, and maybe that's not the right number. I mean, we pulled that from the Social Security Administration. So the Social Security Administration judges whether someone has employed by quarters. And so whatever that 7,200 divided by 4 is what the Social Security Administration currently under federal law determines that you were working that time. Yeah, right. So if you've worked in your lifetime, what SSA considers to be a year. If you worked a year in your lifetime, that's what's in the bill.
You want them to be eligible for this bill. So I was going to ask, and would they also be able to collect TANF, SNAP, and other things as well? Is that?
No.
Why not?
You mean under federal law, where there's like federal programs?
The way your bill is set up, it sounds like because of the lack of income that they have, that they would also be able to receive.
I see.
So it's like you're stacking this.
No, usually no, right? So like to go back to my Waffle House example again, like if someone had worked 5 years at Waffle House and then took a year off to go be with a child or to study in school or whatever, but now is again gainfully employed. Now I know Waffle House doesn't pay a whole lot, but a lot of those workers would be eligible for other federal benefits, and a lot of them wouldn't, depending on whether they're minimum wage or a little bit higher than minimum wage. But to your point, Mr. Chairman, maybe the 7,200 is not the right number, right? I mean, I think you see what I'm getting at. 7,200 may be too low. What I'm trying to do is include a broader section of the population who just by circumstance were not eligible in the last 12 months, but I don't want to actually expand the eligibility because I don't want to balloon the cost of the program. But it seems like that we could do something for the population of people who have worked a lot before that 12 months, are going to work a lot afterward, and would otherwise be shut out entirely.
I just will gotta go back to my original statement. It's always kind of hard to tinker with something we haven't gotten started yet. It's very nerve-wracking.
No, I agree.
A lot of energy.
I totally hear you.
And I'm sure that you saw a lot of shortcomings in my work, and I understand that. That's why we're here today.
I only have admiration from afar, Mr. Chair. I mean, I only regard this committee with the utmost respect and dignity that it deserves. That's why when your second in command here was out for a day, I was weeping in my office, as I told him. But I think the committee did amazing work on the family program. I think you'll probably continue to do amazing work tinkering around the edges. If this is not the year you think it's appropriate to tinker in this way, as always, I respect the judgment of you and the committee, and I'll try to come back next time with better jokes.
And much like your 4-day work week, you may be a little premature, but I'm with you. So
okay.
We have a question, Delegate Harrison.
Thank you. How often would an individual be able to apply for this?
Whenever they have a child.
So an individual, let's use your Waffle House example. They worked from the time that they were 18 to 23, and they have their first child, and they're off for, I don't know, however many weeks, months. They go back and work a little bit, and then they can apply. They have another child, and they can go back again, and then they can do it again and again.
In the bill, yes, I think that their lifetime earnings would stay the same either way. I mean, if the committee wanted to limit it to a one-time use, I don't think that's really a huge amendment. I'd be fine with that.
I was just asking. Thank you very much.
Thank you, Mr. Chair, and thank you, Delegate Bond, for bringing this forward. As you know, myself also as one of the bill sponsors of this issue, and I thank our chairman for working on it as well extensively to make sure it's all for all Marylanders.
Yeah, and thank you for your lead. It's a very important program. I earnestly do really appreciate the committee's work on it.
So
Yeah,
I'm
yours.
kind of piggybacking on Delegate Cheese. I think she asked part of it was where the Secretary of Labor stood on this, and they were before us, I don't know, a few weeks ago now, where this bill was at least supportive of the measure. But it's my understanding that at some point we'll probably get a bill from the other side where this program will be put on hold, unfortunately, but I guess understandably so with the deficit that we're dealing with. I know the chairman said that it's quirky because this program isn't up and running yet, but I was curious if your measure in the other states that it is up and running, was this something that was done in other states, or this was your measure? I mean, your legislation. You understand what I'm saying? Like,
I think
is
so.
there precedent in other?
Yeah, so I mean, I guess to take a couple of those pieces. First of all, I don't think it would delay the program any further. If you look at the fiscal note, it doesn't look like the Labor Department thinks it would push back the program's effective date. I know the committee will consider. I saw that legislation had a Senate hearing about delaying it. To answer your question, the second question regarding what Delegate Cheese said, no other state has basically created an offshoot benefit for people who aren't eligible for the program. Other states have broader eligibility, more generous eligibility for the program itself. No other state has done what I'm proposing.
Okay, so I apologize if it was repetitive. I heard her first part and I wasn't sure about the second part. So thank you, I appreciate that. Thank you, Mr. Chairman.
Delegate Fisher, you had a question? Sure. Are you sure? Okay, that's, usually you guys have this.
I know, I was really hoping. I was hoping that light would blink on, and
I know.
Alas,
sometimes your bills are so far-fetched. I think he just
even he's not even going to waste any breath
I'm
on
just
it.
messing with you, buddy.
No, next time. Next time. No, it's a date. It's a date for next time.
No, I really do appreciate it. I do believe we have a favorable Jennifer Stein.
She got scared.
Yeah, that's not a problem. Is Ms. Stein new? Okay, you're free to go. Thank you very much.
Appreciate y'all.
It's now the unfavorable Grayson Wiggins. I'm sure you'll be brief. You guys can bro it out later. I'm sure you'll be very brief after the line of questioning, right, Grayson?
Thank you, Mr. Chair. We share the concerns articulated.
Outstanding. That's how you do it. Appreciate you. I believe that concludes this bill hearing. Delegate Spiegel. I swore I just saw him.
Where's Spiegel?
Spiegel?
Mr. Spiegel.
Yeah, that was very risky there, bud, but. Which bill is this?
795.
Mr. Chairman, may I bring up my panel?
Wait a minute.
What? Spiegel.
All right. I'm sorry, I just watched the sheriff. I was like, this isn't judiciary, that's down. I see your name, my bad. There you go. And again, welcome Sheriff Carr, Prince George County. We've known each other for years. Excited to hear what you got to say today. Delegate Spiegel, you can go ahead.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Ryan Spiegel in support of House Bill 795. This bill, which has been introduced by Delegate Lopez in prior years, helps public entities in Maryland get access to critical student loan relief through the Federal Public Service Loan Forgiveness Program by making 3 changes to the program in Maryland. First, it requires the Student Loan Ombudsman, which is a position that already exists in Maryland, to develop standardized materials about the program for public service employers in Maryland to provide to their employees both on a yearly basis and at the start of their employment. Second, it allows public service employers to annually certify their employees' status directly with the U.S. Department of Education, assuming that we will continue to have a federal Department of Education, providing a much more streamlined way to certify eligibility. And it requires employers to proactively provide certification forms for those employees who have requested them in the past. And then finally, it clarifies the time requirements for considering when an adjunct or a non-tenured professor at a public college or university is eligible for the loan forgiveness program. Now, as I'm sure you know, student debt has grown out of control in recent years. The Student Borrower Protection Center reports that as of 2020, an estimated 805,000 Marylanders owned $35.5 billion in student loans, with the average Marylander owing nearly $44,000. And that's 2020 data. So with the impacts of COVID and inflation and other economic challenges over the last 5 years, that number is very likely higher now. The financial pressure is even worse for those employees who do the absolutely vital work in Maryland's public sector. Our teachers, our first responders, our healthcare workers, just to name a few, who face lower wages than their counterparts in the private sector, but still have that debt. So HB 795 will not only improve the financial future of many of our residents, but also help us to attract and retain quality state employees who might otherwise choose to pursue employment in the private sector. Congress created the Public Service Loan Forgiveness Program in 2007, enabling public service employees to have their loans forgiven after 10 years of full-time employment in the public sector, while they are also making monthly payments on their loans. But when it came time for that first wave of applicants for loan forgiveness, they faced a 98% rejection rate because of bad industry practices and bureaucracy. And numbers like these can drive employees who are hoping to use their skills for good away from the public sector. Federal loan forgiveness is one benefit the public sector provides that the private industry cannot. It's imperative that we make as many positive changes as we can to incentivize public service workers to choose Maryland and stay in Maryland throughout their careers. Finally, I just want to add that the fiscal note also shows nothing more than a nominal administrative impact, which can be absorbed with existing state and local resources, bearing in mind that the cost of the actual loan forgiveness itself is borne entirely by the federal government. I also want to add, I understand DBM is looking for a friendly amendment to change the way that applicants are notified to include various forms of electronic notification, and we would be happy to provide a sponsor amendment to that effect. And I'm happy to answer any questions. Thank you, and thank you for your accommodation, Mr. Chairman.
Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the committee. My name is Amy Salata, and I'm the Outreach and Advocacy Manager at the Student Borrower Protection Center, a nonprofit policy organization focused on ending the student debt crisis. We are proud to support HB 795. PSLF is a federal program that allows full-time public service workers to earn loan cancellation after 10 years of public service. Federal PSLF regulations define full-time as at least 30 hours a week and provide flexibility for employers to simplify and facilitate the accounting process so that workers in their state are able to access the relief that they are entitled to. Unfortunately, due to the program's confusing eligibility requirements and servicer misconduct in its implementation, many public service workers do not know that they are eligible for PSLF and are never notified by their employer that they are eligible. Some employers even refuse to certify employment for their employees. The Biden administration strengthened the program to make it more accessible. In particular, non-tenure track employees at universities, including adjunct and contingent faculty, can now use a credit multiplier of at least 3.35 to determine whether or not they meet this 30-hour-a-week threshold. Previously, adjunct and contingent faculty were unable to qualify for PSLF because many schools would only certify classroom time, which failed to account for all the time that they spent preparing for classes and grading. Across the country, 8 other states have passed similar bills regarding notification of the PSLF program, and 5 of those states have mandated a multiplier to be used for calculating hours. This bill tackles 2 of the most common issues holding public service workers back from accessing relief under PSLF: a lack of awareness about the program and its benefits, and the issue of adjunct and contingent faculty certification. By mandating that a multiplier be used to calculate hours worked, that qualifying employers certify employment in a timely fashion, and that employers and the Ombudsman regularly share information on the PSLF program, this bill would ensure that those eligible for PSLF in Maryland get to reap the benefits of the program. Thank you for the chance to speak. I'm happy to answer any questions from the committee.
Mr. Chair, Vice Chair, members of the committee, my name is Tanea Moore, and I'm the Director of Policy at the Cash Campaign of Maryland.
CASH stands for Creating Asset Savings and Hope, and we promote the economic advancement for low to middle income families and individuals living in Baltimore and all across the state of Maryland. We are here in full support of this bill to expand access to loan forgiveness by streamlining the certification process for public service loan forgiveness program, ensuring that public service employees, including nonprofit workers, receive credit for their qualifying work. By increasing awareness and simplifying employment certification, this bill ensures more eligible borrowers successfully can access PSLF, reducing financial stress and improving economic mobility. This bill requires public service employers to certify employment without unnecessary delays, preventing workers from losing out on the PSLF due to administrative hurdles. This bill mandates the development of clear, accessible materials to inform public service workers about PSLS eligibility and enrollment, closing the awareness gap that has prevented so many people from benefiting from the program. CASH staffs the Financial Education and Capability Commission, which is chaired by Senator Brooks and Delegate Stein. The commission has 4 core tasks, including improving the financial education and capability of residents in Maryland. The Commission's 2024 report included a recommendation to support increasing the awareness of the PSLF forgiveness program. This recommendation comes from the fact that Maryland has a large public service sector, and many of those employees have student loan debt. These people are working for state and local government, nonprofits, medical institutions, and more. By making PSLF more accessible, Maryland can attain and attract talent in essential fields, including education, healthcare, and social services. For these reasons, we urge a favorable report. Thank you.
Greetings, Chair Wilson, Vice Chair Crosby, and committee members. My name is Dr. Tisa Silver Kennedy, and I'm the founder and executive director of the Maryland Center for Collegiate Financial Wellness. Since 2022, my team has helped public servants, mostly in Maryland, eliminate more than $20 million in debt by way of PSLF. Our efforts began in Bowie and have since gone from Princess Anne to Harford County, with many deliberate and lengthy stops throughout Prince George's County and Baltimore City to visit schools and agencies, including the Maryland Higher Education Commission and the Office of the Sheriff. The biggest barriers we encounter are a lack of awareness among employees and a lack of clarity among employers. This second barrier is critical because PSLF requires a verification of employment. With 4 pieces of information, an individual can complete their part of the application in about 5 minutes. But the most prepared applicants can be stopped by verification. Will their employer sign electronically or demand a paper application, or reject it because the employee entered 38 hours instead of 37.5, not knowing that the application doesn't permit decimals, or refuse to sign for an adjunct because they believe part-timers can't be eligible? These errors lead to rejections, repeat submissions, and giving up. Thankfully, I've had the joy of celebrating many PSLF victories, including a Baltimore County school counselor who'd waited more than a year for her employer to verify her application. She's now in the final phase of buying her first home. A career adjunct in their mid-70s who submitted literally dozens of applications to document their teaching load 1 semester at a time. A 30-year special education teacher in College Park who said, "I can now take what I was going to pay on my student loans and give it to my grandkids." And a Greenbelt teacher who was choosing between replacing bald tires and maintaining her student loan payment. She now has a new truck, which she's using to haul mulch because she's spending more time in her garden. Lives change after a public servant receives PSLF, but for every Marylander that we help get there, there are so many more that get left behind. So I urge you to issue a favorable report on HB 795. Thank you for your time.
Good afternoon, Chair Wilson, Vice Chair Crosby. I am Sheriff John Carr of Prince George's County, and I'm here asking for a favorable report on House Bill 795. As said before, it is imperative that our public safety workers understand that if they are eligible for loan forgiveness, that we utilize that as a tool, not only just for retention, but also for recruiting. This is something to where a lot of agencies are unaware that they have this possibility, and there was an issue in reference to certifying who may be eligible or not. Coming into office, I was able to actually bring in Dr. Tisa to come in and speak to our members of the Prince George's County Sheriff's Office, and we were able to actually have several of our members to be able to relieve their loans from school. As you may know, public safety is looking to try to hire educated individuals, people who have gone through either community college or a four-year institution. Therefore, some of those members are coming in with debt. It would behoove us to make sure that we're able to have some way that those members can actually, after working 10 years, be able to recover some of those funds. So I am asking for a favorable report. This is something from a public safety sector that we need to be able to have any benefits that we can as the job is becoming harder and harder in order to recruit and retain. Thank you.
Thank you, Mr. Chair. Would military service qualify for some of the certification under this legislation?
Yes, military service counts for PSLF.
Okay, good. So would a military member still fall under the 10 years of, to qualify for PSLF?
Exactly, yeah.
Why not half the time? The Biden administration removed military preference for hiring military veterans, and veterans in general put their life on hold for 4 years to serve the nation. Although some veterans do attend higher education while in the military, a lot of, especially the combat arms, cannot. It's very, very hard for infantrymen to attend those type of higher education services. Why not make it 5?
Yeah, I mean, this is really meant to mimic the federal program, which is 10 years, but I agree with you, right? Like, we should be giving as much as possible to our service members, but this is really just meant to mimic that federal program.
Is this what the courts rejected on the federal level that we hear so much about college forgiveness?
No, this
Loan
is
forgiveness?
different. Yeah, this is different, a separate program.
Okay, thank you.
Mm-hmm.
This is a federal program, and we're just changing the certification, correct?
Correct.
So we can't change it to 5 years because that's the federal that's dictating that it's 10. That's why we can't change that portion of it.
Correct.
I just want to make sure. Okay.
Correct.
I got you.
Correct. And if the federal government wanted to change it.
Yeah, I get it, but we can't, he's not asking to, I mean,
You're not
even
going
though
to
I
be asking us
think
to
everybody.
amend it because we can't. Yeah, we understand the nexus.
Okay, thank you.
All right, seeing no further questions, that concludes this bill hearing. Move on to the next bill, Delegate Vogel.
Thank you, Mr. Chair.
Ooh, that's never good. What about Delegate Schindler? All right, let me step up. You got it? Schindler and then Vogel.
Permission to bring up my panel?
Go ahead. And you can
Thank you.
start when ready.
Mr. Chair, Mr. Vice Chair, and honorable members of the committee, thank you so much for the opportunity to speak to you all today. For the record, I'm Delegate Matthew Schindler, and I'm here to present House Bill 632. House Bill 632 seeks to expand Maryland's Workplace Fraud Act by prohibiting all employers in the state from misclassifying employees for the purpose of remuneration. Under current law, only employers in the construction and landscaping industries are explicitly barred from misclassification. However, this issue extends far beyond those sectors. Employee misclassification is a deliberate tactic used by some employers to cut labor costs and evade state and federal tax obligations. This practice strips workers of fundamental workplace protections, including the right to unionize, access to overtime pay, eligibility for unemployment insurance, and disability compensation. It also shifts the tax burden onto employees, further exacerbating financial hardships. Industries particularly affected by misclassification include delivery services, childcare, food service, and other essential sectors. When businesses engage in this fraudulent practice, law-abiding employers are forced to compete on an unfair playing field. Furthermore, local, state, and federal governments suffer significant tax revenue losses, weakening the public resources that benefit us all. Expanding the Workplace Fraud Act will ensure that all employees receive the labor rights that they're entitled to while protecting ethical businesses from unfair competition. No worker should be denied fair wages and benefits, and no employer should be penalized for following the law. I will also note that while this bill has a financial note to accommodate additional staff needed to support this initiative, It is possible the state and local governments are losing potentially millions of dollars due to workers being misclassified or being paid off the books. We were recently made aware that the Attorney General has included this expansion of workplace fraud in their own bill, House Bill 1096, that was filed on February 5th. I thought it was important to continue the course with this bill in case the entirety of HB 1096 isn't adopted. But either way, the expansion of these workplace fraud protections would be a huge victory for our employees, employers, and our state. For these reasons, I respectfully urge the committee to issue a favorable report on HB 632.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Elizabeth Bobo, and I am the Legislative Director for the Maryland State and DC AFL-CIO, and I am here to testify in support of House Bill 632. Workplace fraud and worker misclassification is a widespread and growing problem in Maryland. A recent study on the U.S. Department of Labor Statistics found that Maryland is the worst state in the country for wage theft, on average owing just over $2,000 per worker. Let me repeat that. We are the worst state in the country when it comes to wage theft. In 2009, the General Assembly took a step in combating workplace fraud by passing the Workplace Fraud Act of 2009 and then amending it in 2012. This legislation solely focused on the construction and landscaping industries. HB 632 simply expands on the measure that the General Assembly already passed and amended to combat workplace fraud and protect workers and businesses who follow the law by applying it to all private sector employers in the state. For context, let me provide a glance into our private sector workforce. In 2023, 81% of Maryland's workforce was employed by the private sector. That is a great majority of our labor industry. Workplace fraud is not just an issue of fairness, it is an issue of economic justice. When employers misclassify workers, they are cheating them out of overtime wages, benefits, workers' compensation, and unemployment insurance, which is what they are rightfully owed. This misclassification harms workers and negatively impacts the state's economic vitality. As a result, the state stands to lose millions of dollars in revenue from payroll and income taxes that could otherwise be used to address other challenges and invest back into local economies. HB 632 allows Maryland to take an even greater stance against workplace fraud in a larger capacity, ensuring all workers are treated fairly. With that, I urge a favorable report on House Bill 632. Thank you.
Good afternoon, Chair Wilson, Vice Chair, and members of the committee. My name is Amy Galatly, and I'm an attorney at the Public Justice Center in Baltimore and a resident of District 47A. House Bill 632 offers an edit to Maryland's Workplace Fraud Act to make it clear that no employer in Maryland should misclassify their employees as independent contractors, regardless of the industry in which they work. We've found that employers misclassify employees as independent contractors either because they do not know the difference or because it saves them time and expenses to do so. True independent contractors certainly exist. These are people who are in business for themselves, and they are not entitled, therefore, to unemployment benefits, workers' comp, sick leave, or overtime pay. They're also responsible for handling their own tax liability because no one deducts payroll taxes on their behalf. This bill does not do anything to alter the rights and freedoms of true independent contractors. When employers, for their own advantage, however, misclassify employees as independent contractors, as my fellow panelists have mentioned, the state loses tax revenue and unemployment insurance contributions, and the workers lose out on critical and basic workplace benefits. At the Public Justice Center, we regularly encounter employees who have been misclassified in many sectors, including healthcare, call centers, and various industries that have succumbed to the gigification of work, where the real employer tries to distance itself from its worker by contracting its labor through intermediaries, often through an app. And we believe that by extending the framework of the Workplace Fraud Act to all industries, HB 632 simplifies and clarifies the standard for who is an employee and who is not. As the delegate mentioned, this solution, along with many other important protections for Maryland workers, is also proposed by HB 1096, which the Public Justice Center supports as well, and if it passes, would make this bill unnecessary. Thank you for your time.
Thank you. Ma'am, on the my right, far left, I apologize. Ms. Bobo?
Yes.
Can you, I know you alluded at a study saying Maryland is the worst for wage theft. I'm not going to ask you or put you on a spot. Can you just send where you got that information from to my office? I'm very curious in that.
Yes, I can definitely do that.
Okay. And then Delegate, you're tracking the fiscal note on this one?
Yes.
Okay.
Yes, sir.
So I mean, it's half the expenditure is probably on enforcement is what I'm going to make a presumption of.
Yes, yes.
So with that, do we all still have questions? Okay. Delegate Adams.
I still have more testimony. It's okay. So.
So first off, to the right, you're AFL-CIO?
Yes.
Okay, so the study you talked about. Okay, last year, the Department of Labor came into our committee and did a briefing on the subject. And I'm just curious, did you get a copy of that, of their study? As to how many misclassification issues there are in Maryland?
I do not believe we received a copy of
Okay,
that study.
so at the same time, I guess we'll ask for that report because I'd like to see it, but I'd share with you what Maryland's Department of Labor statistically said on the same issue. So.
Thank you, Mr. Chairman. So just a little question around, thanks for being here. I think this is your first time here in ECM?
It is. Thank you for having me.
Okay, you're welcome. You may not say that afterwards. But you mentioned that the Office of Attorney General has a similar bill, and I noticed your bill is addressing needing 11 more persons to enforce this. Do you have a sense of what they're going to come in with the numbers, or have you had any dialogue with them about how much it would take to enforce this?
I'm not sure exactly what their fiscal note's going to look like. I do believe there are a few additional protections they're asking for, so I would anticipate the fiscal note would be slightly larger.
Okay, okay, well, that's good. Them having a larger one is better than you having a large one. The other question is around the unfavorables. They didn't have written testimony. Do you have a sense of what their issues are going to be?
I'm very curious as to what that could be, so I will be sticking around to hear that.
Okay, thank you very much.
Thank you, Mr. Chair. First of all, welcome my constituent from 47A. But what was the fiscal note? What is $1 million? Is that the question? And then another question is, you said that this would simplify who's an employee and who's not an employee?
I can speak on the fiscal note if you'd like.
Thank you so much.
The final fiscal note for FY26, the net effect was $295,000.
To your second question, Delegate, the current law says that there's a presumption that anyone who's doing work for an employer is an employee in the construction and landscaping industries, but it leaves it somewhat vague as to other industries. And so what this act would do is extend that in general, there's a presumption that anybody doing work is an employee of the person they're working for, unless certain things are met which show that they're actually more like an independent contractor, a person who owns their own business, controls their own schedule, those sorts of things.
And if I may, the current law, as it stands, the current Workplace Fraud Act, has what they call the ABC test that has very well-defined metrics as to what determines whether someone is an employee or a contractor. I'd be happy to send that if you'd like. Yes, ma'am.
Delegate, is this your first bill?
It is. It is, Mr. Chair.
Okay, well, I clearly missed that joke then from the member, so I'm an idiot. I appreciate it. Hopefully we weren't too bad, but thank you so much.
Thank you.
Call up, we have one more favorable. It's Mario Mauricia.
Yes.
Oh, go ahead, sir. When you're ready.
Hi, everyone. It's an honor to be here. I'm Mario. I'm political representative for 32BJ SEIU. Honorable members of the committee, it is a pleasure here to submit testimony in support of House Bill 632, which would amend the Workplace Fraud Act to extend the acts to protections that go against independent contractor misclassification in all industries in the state. 32BJ SEIU represents over 175,000 members up and down the East Coast, 4,000 members in Maryland. On behalf of our union and members, we urge the legislature to support HB 632, which would help protect workers in property service sectors from independent contractor misclassification. This abusive practice can cheat workers of wage and hour, paid leave, and anti-discrimination practice, subject them to higher taxes, strip them workers of compensation and unemployment insurance benefits, and rob them the right to organize. The consequences of independent contractor misclassification can be devastating. At 32EJ, we have seen janitorial firms fail to make tax withholdings and pay their portion federal payroll taxes, burdening workers with much a higher tax rate and responsibility for all tax filings. Another consequence of independent contractor misclassification is that responsible employers may find themselves unable to compete with lower bid companies that reap the benefits of artificially low labor costs. This is especially a problem in janitorial and property service work. Employers in these sectors can gain competitive advantage by misclassifying workers and illegally driving down payroll costs, undercutting above board companies that have negotiated contracts with 32BJ or otherwise attempt to play by the rules. This also undermines good union standards that allow regular working people to support their families and build strong communities in Maryland. Extending protections against independent contractor misclassification will give workers advocates more tools to fight violations and raise the consequences for companies that seek to strip workers of employee status and protections. It will also send a clear message to workers, employers that the state takes independent contractor abuse seriously and hopefully encouraging greater compliance with workplace laws. Thank you for your attention on this important issue and to protect working families in Maryland.
Thank you. Sir, real quick, can you just state your full name for the record?
Mario Murcia.
Thank you. And then delegate, just when, after the hearing, when you get back to the office, just look at HB 1096. We have not heard that bill in this committee yet, but it is not the exact same, but it is similar and touches around your issue. All right, with that concludes the favorables. We will now go to the unfavorables. Mike O'Halloran, Grayson Wiggins. Start when ready.
I'll fire off. Good afternoon, Mr. Vice Chairman, members of the House Economic Matters Committee. For the record, my name is Mike O'Halloran here today representing National Federation of Independent Business, and we are respectfully opposed to House Bill 632. I certainly don't need to tell members of this committee how complex I dare say many NFIB members would say intrusive the Workplace Fraud Act is, but the complexities are various, including the penalties, quite frankly. So asking a small business, generally outside of construction, to now understand and then be able to appropriately apply the ABC test when honestly they're only using 1099 employees for design needs, IT needs, writing up copy for a web page. The point being is that now you're bringing in a huge swath of industries, frankly, as the bill would stipulate, all private and sector employers now under this workplace fraud statute. That's a big ask of that community. So, I'll leave with that. I know my colleague from the chamber probably has more expertise on the issue given his illustrious background, so I'll kick it over to him. Thank you, Mr. Vice Chair.
Thank you, Mr. Vice Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. I share Mike's concerns. I just wanted to highlight a couple of things that you just heard. So, Delegate Adams, I do have a copy of the report from 2023 from the Division of Labor and Industry, and there were 6 complaints on worker classification made to the Maryland Department of Labor in 2023. The DLS website says the 2024 report has not been submitted. I don't know if the department is working on that. I know that sometimes things get lost in the shuffle. Additionally, I did just want to note, I'm personally just a little bit confused because I've been working on this issue for about 5 years for different clients, and some of the same groups that are asking to expand this are the same groups that came in last year and said that the department didn't have the resources they needed to enforce the provision on the construction and landscaping side. So if we haven't allocated additional resources, my question would be, why are we now here the following year asking to expand this from 185,000 establishments to 2 million workers? And the reason I'm concerned by that is because having worked at the department and being familiar with this issue, I have seen situations where businesses were wrongfully accused. And that is a very significant issue when you look at the penalties that we just raised last year under this statute. And so my concern is that if we haven't allocated resources, and the fiscal note says that the Department of Labor is working to strengthen enforcement of the existing program, why are we expanding this? And my concern is that businesses are going to get caught up and potentially be wrongfully accused of doing something that they're not doing because the department is overloaded by adding 2 million additional workers to this. And then finally, I would just note, because it was raised by the representative from the Public Justice Center, this presumption issue, we're still working through that, but that sounds a lot like AB 5 from California, which was ultimately repealed and replaced, and would cause significant issues in the tech industry. Thank you.
I got you. One second. Grayson, how do you juxtapose 6 complaints filed in 23, we don't know how many in 24, versus the prior panel that said it's one of the worst states for misclassification?
So they said one of the worst states for wage theft. I had this discussion yesterday with some representatives from the Attorney General's office. That is not specific to worker classification, is my understanding. I haven't been able to work all the way through the U.S. Department of Labor report, but in the articles I've seen and the part of the report that I've gotten to, I don't believe it's specific to worker classification. So I think comparing the two would be a misconstruing the issue.
You're right, they're different topics. My fault. Delegate Adams.
Thank you, Mr. Chairman. So, I mean, look, that report from the Department of Labor, I'm going to read it. Like, I don't know where I'm going to get it. Hopefully I get it, and maybe everybody in the committee gets it. But to say that we are the worst state in the union on this subject, it better be backed up with some facts that actually relate to 1099, if that's what's going to be presented by way of the bill. And I assume you feel the same way about it.
Yes, sir, and we'll be happy to get that report to the committee. One of the reasons it may have been difficult to find is that I believe the Labor and Industry Division started to group that report with others in a larger report, which makes sense from a time perspective. But I will make sure that the committee gets that report.
So it's not lost on me that there's a bill next week, but I'm not going to ignore the bill that's in front of us, which is basically the same subject. And let me just say this. For 8 years under the Hogan administration, their job wasn't to come down and slam and put companies out of business. You know what they were doing? They were working with companies to get them into compliance. And so if there were investigations, if there were complaints, it wasn't this bill where we're trying to slam businesses. It's not going to be a bill next week where I promise you I'll be here and talking at length about it. It's going to be government can and should partner with businesses if they think there's a legitimate reason to do that before you bring the hammer down. And I got to tell you, the hammer came on my head in the seat that you're sitting in back in 2013 and 2012. And I don't wish that on my worst opponent in business. And before we start passing bills like this, we better start thinking in the state of Maryland about the tax revenue that we receive from businesses and the business climate that we're presenting over the next couple of years, okay? And these bills do not send the message to Maryland that we're leaving no one behind. Because I can tell you, every business person that watches something like this happen, and bill next week with the Attorney General, will absolutely conclude that we've got some structural problems in our state and our climate that we're trying to create economic development and prosperity for everyone.
But, and Delegate, and Mr. Vice Chairman, if I may, just for the edification of the committee, because it was brought up by the proponents, you know, the study of Maryland being #1 in wage theft, you know, the study says that it did an analysis from the U.S. Department of Labor data. But the group that did the study, it's an outfit, a financial education outfit called the GOAT Academy, that if you just do a simple Google search, you'll see it's, you know, and I don't mean to besmirch anybody, but I don't want it to give the appearance that it is somehow, you know, a government survey or a government ranking. No, it was somebody who also offers free stock market investing mini courses online, you know, parsing through some data. And to be perfectly honest, you know, to quote folks from DLS, we can make the numbers say whatever we want. So I just, for the edification, you know, when you hear from proponents of this bill, and I'm sure next week, that, you know, Maryland is the worst state when it comes to wage theft, I just caution on where we're deriving these rankings from.
Yep, thanks. And that's kind of why I want to see the study and see who did it. Delegate Boafo.
Thank you, Mr. Vice Chair. We've had a lot of conversation on this topic, and I know my good friend from the Eastern Shore and I spent a lot of time talking about worker misclassification last year, and I just want to thank him publicly for the work we did on that. I just want to echo the comments from the gentleman from the Eastern Shore in saying that the report that we got last year showed that we were missing a lot of tax dollars because of wage theft in particular. And so I think that report, Delegate, is going to be significant to get back so we can really get a full understanding of what's going on. Because to the gentleman's point, not only are we losing, we passed my bill last year, I don't want to continue to put onuses on businesses. I do understand that. But I also understand that if we don't get a handle on the wage theft issue, we're also talking about loss in tax money for the people of our state. So I just want to echo the gentleman's comments and say to both the delegate and to the opposition, let's get that report.
Okay, that concludes this hearing. Next, we will go to the final bill of the day, House Bill 582, Delegate Vogel. Delegate, you can just bring up your panel, start when ready.
Mr. Vice Chair, committee members, apologies for being a little late and glad to see you're feeling better, Mr. Vice Chair. Here with House Bill 582, which looks to raise the threshold for which salaried employees can receive overtime pay. Many of you might be familiar with a rule by the Department of Labor last year that looked to raise this threshold to $58,656. A federal judge in Texas ruled against that, putting an end to this rule, keeping it at, I believe it's right around $36,000 now, the threshold. What this means is that salaried employees who are making equivalent to $17 an hour, if they work beyond their 40-hour weeks, they are not receiving overtime pay. I consider that to be unfair for the workers of our state. So House Bill 582 would raise the threshold to what the Department of Labor sought to raise it to under their federal rule. And it also provides an important caveat, I would say, which is that if the federal government does raise the threshold in the future, whichever threshold is higher is the one that would be met. I will just add one last piece quickly. The $58,656 threshold is what was set by the Department of Labor. It was going to be phased up to that amount. We can argue what threshold makes the most sense, but I also think it's important to codify this protection regardless of what the threshold is, considering the fact that there is conversation of looking for a way to undermine, folks looking to undermine that threshold, looking to make it so that workers across the country do not have those overtime protections if you're a salaried worker. So putting those protections in place here in the state would be important in and of itself. With that, I urge a favorable report on House Bill 582.
Thank you, Vice Chair Crosby and members of the committee. Thank you for inviting me here, Delegate Vogel, to share the IBEW's perspective on House Bill 582, addressing overtime compensation for salaried employees. My name is Roland Carter. I'm a 26-year member of the International Brotherhood of Electrical Workers. I am a journeyman lineman. Strengthening work protections on state level is critically important, especially now as federal workers and labor policies on the national level are under threat. On behalf of the IBEW's 14,000 members in the state, I stand in strong support of Maryland House Bill 582. While the Trump administration quickly honed in on federal workers, attacks on workers' pay in general may not be far behind. In Project 2025 playbook is employed, the administration is likely to make eligibility for overtime more confusing for workers to navigate and easier for employers to abuse. Overtime pay increases workers' paychecks and helps protect the home and family time. Without these protections, employers can force them to work 60 to 70-hour work weeks without any extra pay. Overtime eligibility and excess are already among the most common forms of wage theft. Most violations face minimal consequences. House Bill 582 will provide clearer guidance and more enforcement, not additional flexibility for employers. The IBEW urges you to support House Bill 582, which is essential for upholding economic security for Maryland workers, particularly in the new era of uncertainty. Thank you.
Well, I wasn't going to ask any questions, and then I felt compelled after that last speech. So, Delegate, the common denominator among the unfavorables is the potential of unintended consequences, right? Like an employer's in a situation to make the numbers work, and to comply, they would essentially have to reduce these more experienced employees to an hourly rate or whatever. I mean, so do you feel like there's any issue with that? I mean, are you concerned that that bill could do just that?
I mean, thank you, Delegate, for the question. I think it depends on which of the unintended consequences we're discussing here. You know, the reality right now is that if you look at the equivalent hourly rate, you're talking about a worker who's essentially making $17 an hour if they were working 40 hours a week. Those workers, if they were hourly workers, they would be getting overtime pay beyond those 40 hours. If you're making the equivalent of that in a salaried amount, the equivalent of $17 an hour salaried, you can work 50, 60 hours a week and not be receiving fair compensation, fair pay. So look, I happen to believe that the more workers contribute to their businesses, the better their businesses do, right? We want that output, but if workers are working those hours, they should be compensated for the work that they're doing.
Okay. All right, thank you, Mr. Chair.
Question for you, Delegate.
Yeah.
Would this apply to remote workers?
Thank you for the question, Delegate. I don't see why there would be a specific exception depending on how they're classified in terms of their salaries and what their compensation is. I don't see anything in the bill that would exempt remote workers.
Okay. All right. Seeing no further questions, that concludes the favorables. We'll go to the unfavorables. Grayson Wiggins, Michael Halloran, Kaylee Locklear. Mike, be quick. I don't see the other two. Go. No.
Yes, sir. Sorry.
Hurry up, Mike.
I mean, I can give you the cliff notes real quick, and I'd be happy to do so. For the record, Mr. Vice Chairman, members of the House Economic Matters Committee, my name is Mike O'Halloran, and I'm here today representing NFIB, which represents small businesses. In the simplest manner, you know, the cost implications for small businesses, I cannot be understated. We're talking about a roughly 65% increase to the salary threshold, which would therefore, Delegate Pippi, to your point, the law of unintended consequences will probably go against the intent of the sponsor. And I'll end with this. I mean, it's to say nothing of the practical implication of the bill, the final line of the bill, all by October 1 of this year. So again, those are just a couple of the quick and dirty issues that we have with the bill, and I'm sure there are more to be had. Thank you.
All right. Seeing no questions and not seeing any more unfavorable witnesses in the room, that concludes the bill hearing and the bill hearings for all of today. Thank all the members and see you tomorrow.